Greetings to one and all. You are listening to MMJC updates. In today's edition, we will be discussing about one adjudication order issued by ROC and one NCLT order issued by NCLT Kochi bench. So first about the ROC order. The ROC has penalized a company for non-compliance of Section 187. So in the facts, company had in year 2017-18 company had issued some shares to its managing director against as a purchase consideration for business of the managing director, which was purchased by the company from the managing director. Also the company acquired the assets which belong to this business, and for the consideration of that shares were allotted. However, the properties which were purchased remained in the name of managing director itself for the 4 years, that is from 17-18 till 21-22. So, Section 187 basically says that all the properties and securities held by the company should be held in the name of the company itself. So in this case, as I mentioned, the properties like some fixed immovable properties, office premises, also some movable properties like FDs and mutual fund investments, etc., were held in the name of the managing director and not in the name of the company. This non-compliance was highlighted by the statutory auditor of the company in his report. When there was an inspection undertaken by the ROC, he noticed this non-compliance and penalized the company. Penalty was levied on the managing director and the company. So the learning from this order is that companies should take care that all the assets are held in its own name. At times, it so happens that due to some operational convenience, properties are held in the name of director or promoter or any other person related to the company. However, this can cause a non-compliance, and especially this may happen when small sole proprietary kind of businesses are acquired, because when there are mergers, etc., all due diligence is properly done. So companies should take care of this. Moving on to the NCLT order. So this order is issued by NCLT Kochi bench in the case pertaining to operation and mismanagement. So with respect to facts, the petitioners who had filed the complaint of operation and mismanagement were shareholders as well as directors of the company. They had alleged that company had done multiple transactions which were in violation of multiple sections of Companies Act, some of which related to investment activities and grant of loans, etc. So the main allegation of the petitioners was that the company had not complied with the requirements of obtaining proper approvals through board meetings, and the notices for such board meetings were not duly given to the petitioner specifically. So on this allegation, the respondents, that was the company management, said that the notices were duly given, but through WhatsApp groups. There was a WhatsApp group wherein there were directors and also some employees of the companies were the members. And the respondents, that is the company management, said that we had circulated a notice of board meeting through this WhatsApp group. So in its decision, the NCLT has clarified that notices sent through WhatsApp or other such informal communication apps are not valid notices. Section 173 subsection 3 provides some basic requirements which have to be complied to call a notice as a valid notice, and it basically aims at ensuring that the notice should be specific and it should be addressed to that specific person. When notice is sent through WhatsApp, it is an informal communication, and the whether the notice is received or not cannot be tracked. Hence, it is a informal and mean of communication, and notice is invalid. So when company should ensure that notices are not sent through WhatsApp, or even if they are sent, the official mail for notice and agenda and all other documents should be also sent in addition to sending notices through WhatsApp. So that's it in this edition of MMJC updates. Please feel free to write to us about your feedbacks. Thank you.